Good evening, everybody. News Now Wyoming bringing you breaking news from the Supreme Court to the surprise of absolutely nobody. The Supreme Court has removed the moratorium on evictions. Even when the CDC passed it, they said, we know this is illegal. We know this is going to get tossed. And so it's no surprise to anybody at all. Obviously, the Democrats are already out there crying about it, but whatever. Here we go, you guys. So we're going to take a look at this ruling. I have not actually read it. Per Curiam, the director of the CDC's, has imposed a nationwide moratorium on evictions of any tenants who live in a county that is experiencing substantial or high levels of COVID-19 transmission and who make certain declarations of financial need. The Alabama Association of Realtors obtained a judgment from the U.S. District Court for the D.C. vacating the moratorium on the ground that it is unlawful, but the D.C. Court stayed its judgment while the government pursued an appeal. We vacate that stay, rendering the judgment enforceable. The District Court produced a comprehensive opinion concluding that the statute on which the CDC relies on does not grant it the authority it claims. The case has been thoroughly briefed before us twice, and careful review of that record makes clear that the applicants are virtually certain to succeed on the merits of their arguments that the CDC has exceeded its authority. It would be one thing if Congress had specifically authorized the action that the CDC has taken, but that has not happened. Instead, the CDC has imposed a nationwide moratorium on evictions in reliance on a decades-old statute that authorizes it to implement measures like fumigation and pest extermination. It strains credulity to believe that this statute grants the CDC the sweeping authority that it asserts. Hold on, does this say per curiam? Okay, so in March 2020, Congress passed the Coronavirus Aid to alleviate burdens caused by the burgeoning COVID-19 pandemic. Among other relief programs, the act imposed a 120-day eviction moratorium for properties that participate in federal assistance programs or were subject to federally backed loans. When the eviction moratorium expired in July, Congress did not renew it. Concluding that further action was not needed, the CDC decided to do what Congress had not. The new administratively imposed moratorium went further than its statutory predecessors, covering all residential properties nationwide and imposing criminal penalties on violators. The CDC's moratorium was originally slated to expire December 31st, 2020, but Congress extended it for 1 month as part of the second COVID-19 Relief Act. As the new deadline approached, the CDC again took matters into its own hands, extending its moratorium through March, then again through June, and ultimately through July. CDC relied on 361A of the Public Health Service Act for authority to promulgate and extend the eviction moratorium. That provision states that Surgeon General, with the approval of the Secretary of Health and Human Services, I'm about to sneeze, you guys, so excuse me. Okay. Never mind, I guess maybe not. I still feel it, you know. There we go. Oh my gosh. Excuse me. It is authorized to make and enforce such regulations as in his judgment are necessary to prevent the introduction, transmission, or spread of communicable diseases from foreign countries into the states or possessions, or from one state or possession into another state. Sorry about that, another sneeze. Another state or possession. For purposes of carrying out enforcing such regulations, the Surgeon General may provide for such inspection, fumigation, disinfection, sanitation, pest extermination, destruction of animals or articles found to be so infected or contaminated as to be sources of dangerous infection to human beings, and other measures as in his judgment may be necessary. Originally passed in 1944, this provision has rarely been invoked and never before to justify an eviction moratorium. Regulations under this authority have generally been limited to quarantining infected individuals and prohibiting the import or sale of animals known to transmit disease. Realtor associations and rental property managers in Alabama and Georgia sued to enjoin the CDC's moratorium. The U.S. District Court for the District of Columbia granted the plaintiff's summary judgment, holding that the CDC lacked statutory authority to impose a moratorium, but the court stayed its order pending appeal. It reasoned that even though the government had not shown a substantial likelihood of success, it did make a lesser showing of a serious legal question on the merits, which the courts had warranted granting a stay when the remaining stay factors weighed in the government's favor. So the D.C. Circuit agreed, though it rated the government's arguments more highly. This court declined to vacate the stay. Justice Kavanaugh concurred, explaining that he agreed with the district court. And this is the part to me. And this is how they knew where this was going to come down, right? They knew how the Supreme Court would be ruling. At least 5-4. Turns out to be 6-3. Justice Kavanaugh concurred, explaining that he agreed with the district court that the CDC's moratorium exceeded its statutory authority, but because the CDC planned to end the moratorium in only a few weeks, and because that time would allow for additional and more orderly distribution of congressionally appropriated rental assistance funds, he concluded the balance of equities justified leaving the stay in place. And then 4 of them noted they would vacate the stay. Moratorium expired on July 31st. 3 days later, the CDC reimposed it. Apart from slightly narrowing the geographic scope, the new moratorium is indistinguishable from the old. With the moratorium once again in place, the plaintiffs returned to the district court to seek vacatur of its stay. The district court agreed with the plaintiffs that the stay was no longer warranted for 2 reasons. First, the government was unlikely to succeed on the merits. We knew that. Second, the equities had shifted in the plaintiff's favor. Vaccine and rental assistance distribution had improved since the stay was entered, while the harm to landlord had continued to increase. But the court concluded that its hands were tied by the law of the case in light of the D.C. Circuit's earlier decision not to vacate the stay. That denial was followed by one more stop at the D.C. Circuit, where that court again declined to lift the stay. Again, you guys, the D.C. Circuit. Yeah, I can't believe that they actually were ever attorneys. Still are, technically. Having passed through the lower courts twice, the plaintiffs return as applicants to this court to once again ask us to vacate the district court stay. The district court concluded that its stay is no longer justified under the governing 4-factor test, and we agree. The applicants not only have a substantial likelihood of success on the merits, it is difficult to imagine them losing. The government contends that the first sentence gives the CDC broad authority to take whatever measures it deems necessary to control the spread of COVID-19, including issuing the moratorium. But the second sentence informs the grant of authority by illustrating the kinds of measures that could be necessary. These measures directly relate to preventing the interstate disease by identifying, isolating, and destroying the disease itself. CDC's moratorium, on the other hand, relates to interstate infection far more indirectly. If evictions occur, some subset of tenants might move from one state to another. Some subset of that group might do so while infected with COVID-19. This downstream connection between eviction and the interstate spread of disease is markedly different from the direct targeting of disease that characterizes the measures identified in the statute. Reading both sentences together rather than the first in isolation, it is a stretch to maintain that 361A gives the CDC authority to impose this eviction moratorium. Even if the text were ambiguous, the sheer scope of the CDC's claim authority under 361A would counsel against the government's interpretation. We expect Congress to speak clearly when authorizing an agency to exercise powers of vast economic and political significance. That is exactly the kind of power that the CDC claims here. At least 80% of the country, including between 6 and 17 million tenants, are at risk of eviction, falls within the moratorium. While the parties dispute the financial burden on landlords, Congress has provided nearly $50 billion in emergency rental assistance, a reasonable proxy of the moratorium's economic impact. And the issues at stake are not merely financial. The moratorium intrudes into an area that is particular domain of state law, the landlord-tenant relationship. Indeed, the government's read of 361A would give the CDC a breathtaking amount of authority. It is hard to see what measures this interpretation would place outside the CDC's reach, and the government has identified no limit beyond the requirement that the CDC deem a measure necessary. Could the CDC, for example, mandate free grocery delivery to the homes of sick or vulnerable? Require manufacturers to provide free computers to enable people to work from home? Order telecommunications companies to provide high-speed internet service to facilitate remote work? Wow, actually, that I never even thought of those far extremes, you guys. Those are great things that are coming up with from the Supreme Court there, of how far would this go under their own interpretation. This claim of expansive authority is unprecedented. Since that provision's enactment in 1944, no regulation premised on it has even begun to approach the size or scope of the eviction moratorium, and is further amplified by the CDC's decision to impose criminal penalties of up to $250,000 fine or 1 year in jail on those who violate the moratorium. I didn't realize that the CDC's decision actually imposed criminal offenses, which, yeah, I would question. I would question that legality, even if the rest was legal. Can a executive agency decide on the fines and penalties of its executive actions? I would be really interested to see that part just on its own be decided in the courts. The equities do not justify depriving the applicants of the district court's judgment in their favor. The moratorium has put the applicants, along with millions of landlords across the country, at risk of irreparable harm by depriving them of rent payments with no guarantee of eventual recovery. Despite the CDC's determination that landlords should bear significant financial costs of the pandemic, many landlords have modest means, and preventing them from evicting tenants who breach their leases intrudes on one of the most fundamental elements of property ownership, the right to exclude. As harm to the applicants has increased, the government's interest has decreased. Since the district court entered its stay, the government has had 3 additional months to distribute rental assistance funds to help ease the transition away from the moratorium. Whatever interest the government had in maintaining the moratorium's original end date to ensure the orderly administration of those programs has since diminished, and Congress was on notice that further extension would almost surely require new legislation, yet it failed to act in the several weeks leading up to the moratorium's expiration. It is indisputable that the public has a strong interest in combating the spread of the COVID-19 Delta variant, but our system does not permit agencies to act unlawfully even in pursuit of desirable ends. 1952 case, Youngstown Sheet, concluded that even the government's belief that its actions was necessary to avert a national catastrophe could not overcome a lack of congressional authorization. It is up to Congress, not the CDC, to decide whether the public interest merits further action here. It is federally imposed eviction. If a federally imposed eviction moratorium is to continue, Congress must specifically authorize it. The application to vacate stay presented to the Chief Justice and by him referred to the court is granted. So ordered. So did he? Does this say? So per curiam, I think is. Yeah, it doesn't say who actually wrote it, but there was. But that did read like Robert, so. I was really hoping that Kavanaugh would write it. Because Kavanaugh's the one that said, don't do this again, because I'll vote against you if you do. So I was really hoping for a decision by him. Alright, so dissenting. The CDC has issued an order that, in light of the rise of the COVID-19 Delta variant, temporarily prohibits certain evictions in high-transmission counties through October 3rd. Today, this court, as an emergency matter, without full briefing or argument, blocks that order by vacating a lower court stay. I think the court is wrong to do so, and I dissent. It is far from demonstrably clear that the CDC lacks the power to issue its modified moratorium order. The CDC's current order is substantially more tailored than its prior eviction moratorium, which automatically applied nationwide. Justified by the Delta variant surge, the modified order targets only those regions currently experiencing skyrocketing rates. If a covered county no longer experiences substantial or high levels of community transmission, the order will no longer apply there. So today, however, that figure is over 90%. Unlike under New York's moratorium, landlords remain free to challenge in court the truthfulness of a tenant's declaration that he or she qualifies for the order's protection. The CDC issued this modified moratorium order pursuant to its powers under the 361. We already read the statute. Provision's plain meaning includes the eviction moratoria necessary to stop the spread of diseases like COVID-19. When Congress enacted 361A, public health agencies intervened in the housing market by regulation, including eviction moratoria to contain infection by preventing the movement of people. See one-day influenza record, New York Times, 1920. No. If that happened in 1920 and the new building didn't come out until 1944, does he say when this passed? What does something that happened in 1920 have to do with a bill that passed in 1944? You're really reaching there, bud. Section 361A's second sentence is naturally read to expand the agency's powers by providing congressional authorization to act on personal property when necessary. Could also be read to provide emphasis regarding particular enforcement measures. Applicants urge, and today's per curiam agrees, that the second sentence should instead be read to cabin the CDC's authority. Not only does that reading lack a clear statutory basis, but the second sentence goes on to empower the CDC to take other measures as in its judgment may be necessary. Furthermore, reading the provision's second sentence to narrow its first would undermine Congress's purpose. The per curiam also says that Congress must speak more clearly to authorize the CDC to address public health crisis via eviction moratoria, but it is undisputed that the statute permits the CDC to adopt significant measures such as quarantines, which arguably impose greater restrictions than do limits on evictions. Indeed, the current Congress did not bristle at the government's reading of the statute. 2020, Congress extended the CDC's moratorium issued under Section 361. In any event, lower courts have split on this question. Certainly, this court did not resolve the question by denying applicants' last emergency motion, whatever one justice might have said in the concurrence. The scope of that challenged moratorium, the balance of the equities, and the public interest were all different. As is typical in this court's emergency orders denying extraordinary relief, we said almost nothing about our reasons for declining to act. Second, the balance of equities strongly favors leaving the stay in place. Applicants say they have lost thousands of dollars in rental income. That injury is lessened by the moratorium's orders, directives that tenants have an obligations to make as close to the full rent payment as possible. You're a freaking idiot. Like, all these people are going to pay the last 18 months of back rent. If they could pay that all at once, they would have paid it. Congress, to compensate for the shortfall, Congress has appropriated more than $46.5 billion to help pay rent and rent arrears. It may, as applicants say, take time to get that money, and that is an injury. But compare that injury to the irreparable harm from vacating the stay. COVID-19 transmission rates have spiked in recent weeks, reaching levels that the CDC puts as high as last winter, 150,000 new cases per day. To date, the CDC estimates that 38 million Americans have been sickened. 629,000 have died. This week, the CDC calculates average new daily hospital admissions at 12,000. Third, the public interest is not favored by the spread of disease. The courts do not make law. I realize that the courts think that they make law all the time. That is not their purpose. That is not their general purpose. They do not make law. They do not decide, oh, well, this is just unfair and we should agree. That is not the court's job. That is Congress's job. Public interest strongly favors respecting the CDC's judgment at this moment when over 90% of... Yeah, sorry you guys. To get back to that whole point about courts making law, that's my biggest problem with qualified immunity. Is it was enacted by the court on its own without a law. If Congress passed a law back in 1973 or 4, whenever, that said, here's 1983, but here is qualified immunity that will bar under these situations. If Congress did that, I actually wouldn't be bitching about qualified immunity as much as I do. I'd probably be complaining about how they actually tailor it. But if Congress passed a law, you would take away most of my argument. The fact is, Congress did not pass that law. Congress passed a law, USC 42, 1983, that said here is what can happen if a government official violates your rights, that they can be sued. That is what Congress passed. And then the courts turned around a few years later and said, oh, but not cops if they fall under this. Pure bullshit. And that's exactly what you see. You see these justices trying to do here is, even though the law doesn't say it, we should read it because it's in the public's best interest, in my opinion. Freaks, man. That is not your job. That is, let Congress do it. On applicants' last trip to this court, they argued that the downward trend in COVID-19 cases and the effectiveness of vaccines left no public health rationale for the CDC's moratorium. These predictions have proved tragically untrue. Today, they show just how little we may presume to know about the course of this pandemic. And so when does it end? When does it end? That is my question to you, Your Honor. Do you call justices Your Honor or what? But if it pleases the court, Justice Breyer, where does it end? And I want you to answer the question that they ask above. Where does the authority of the CDC end? How far can they take it? Could they force everybody, every business to actually allow work from home? Is that something the CDC can actually impose? Where does it end? And to my viewers, because I know Justice Breyer would never watch my videos, where do you think it should end? Do you agree with this decision or do you disagree? What do you think of the power of the Supreme Court? And where am I right? Where am I wrong? So applicants raise contested legal questions about an important federal statute on which the lower courts are split and on which this court has never actually spoken. They just spoke. These questions call for considered decision-making informed by full briefing and argument. Their answers impact the health of millions. We should not set aside the CDC's eviction moratorium on this summary proceeding. The criteria for granting the emergency application are not met. I respectfully dissent. And that was Justice Breyer, joined by Sotomayor and Justice Kagan joining. So it was a 6-3 decision. What do you guys think? Who's right? Which side of the fence is right here? What do you think of my own opinions on it, or what do you think about just the Supreme Court in general? Let me know in the comments below. Make sure you hit that like and subscribe.